All right, everybody, thanks for watching this presentation. We're going to be focusing on a case out of our textbook in Chapter 1, Case Studies in Sport Law, 2nd edition by Andrew Pittman, John Spengler, and Sarah Young. This case can be found in the first chapter of that book. It is Sandison versus the Michigan High School Athletic Association. Very interesting case, I think, for the fact that it deals with age. In part, and so I think it's important for athletic administrators to understand going forward what this ruling has on other cases that may come forward and how things could be handled. So let's go ahead and dive on in and take a look at this case. We'll get to take a look at the arguments, the court ruling, and how it affects athletic administrators' jobs nowadays. So the background, this was brought up in 1995 in the 6th Circuit Court. There were two students that sued their school corporations and the Michigan High School Athletic Association. So the MHSAA is the governing body. Schools signed contracts to be a part of those associations. And so the students ended up suing both the corporation and the athletic association. Those students were Ronald Sandison and Craig Stanley. Both of these students, what's important to note, both had disabilities, and they were both over 18 years old. So we're going to get a double whammy, so to speak, here with their lawsuit. So it's important to keep that in mind. The arguments. So Sandison and Stanley filed an action against those entities, their high schools and their athletic association, alleging that the Rehabilitation Act of 1973, Titles 2 and 3 of the American Disabilities Act, had been violated because each student suffered from a learning disability. And then before reaching high school, this is where it gets interesting, each fell behind the typical school grade for the children of their age. So that means our plaintiffs in this case started their senior years in the fall of 1994, but by then had turned 19 years old. Now, by MHSAA rules, you cannot participate in one of their sanctioned sports if you turn 19 by September 1 of the school year. So, keep that in mind. However, the plaintiffs actually won the preliminary injunction relief. So the students think they're discriminated based on a disability. Meanwhile, the MHSAA says we're just adhering to our age policy that we've had instituted for a long time. So a little bit of background, some more here, so to give you some context. Sandison started ungraded kindergarten at age 6 rather than at the usual age 5. And it was not until age 7 that he was actually considered a student in graded kindergarten. So therefore, that 2-year delay actually placed Sandison 2 school grades behind his age group. Now, Sandison competed in cross country and track during his first 3 years of high school. So obviously, if you were over or if you were 19 by September 1, you couldn't compete. Now, for Stanley, he repeated kindergarten and then spent 5 years in a special ed classroom. He made the transition into regular classrooms by entering the 4th grade rather than the 5th grade. So, with that information, he's actually 2 school grades behind his age group. Now, he attended a different high school than Sandison. And he also ran on the cross country and track teams during his first 3 years. But he turned 19 a few months before starting his senior year. So basically what we have here, the courts are saying, or the plaintiffs are saying, we're discriminated based on a disability that we had, our learning disability that put us back. And the MHSAA is saying we're just adhering to our age protocol that we have in place. So as I mentioned earlier, the court actually ruled in favor of the students. So in August of 1994, the district court that they went to granted the plaintiffs a temporary restraining order permitting the students to actually run in any upcoming high school cross-country races. And then in early September, they issued a preliminary injunction, which the district court entered, meaning that it was over. The district court restrained all three defendants from preventing the plaintiffs from participating in interscholastic cross-country and track competition. The court explained that it relied only on the Rehab Act and the ADA to support the preliminary injunction. The court held that by managing interscholastic athletic events, the MHSAA operated places of education and places of entertainment under Title III of the ADA, which prohibits disability discrimination in places of public accommodation. So basically, we're looking at, the court is looking at one piece of this, which doesn't seem right. And that's actually what our authors of this textbook end up finding, is that, the court really erred in their findings on this case. And so it's important to keep that in mind as we, move forward with this. So, what does this do for us as athletic administrators, I think is important. So we know that the court, according to our textbook, which is written by Pittman, Spengler, and Young, it's Case Studies in Sport Law, it's the second edition. They say the court erred basically because we're only looking at one piece, and some of that didn't happen. So I think, with that being said, us as athletic administrators, I think we need to be vigilant about our athletes. We need to understand where they're at in their life. We need to understand any circumstances that might come up and try to communicate those and address those as soon as possible, instead of waiting for something to happen. So if we know something is coming up, it's best to get with them and get with families to start preparing for these sort of things. And then really, it goes back to the age-old question, or the age-old saying that no question is a dumb question. So if we're unsure, we just need to check with our athletic association, right? If we're unsure about age requirements or need a clarification, then there's no reason why you can't call your athletic association and ask. Or you could even ask other athletic directors from the area. Ask them what they would do. But it comes down to communication and figuring out and being on top of what's coming and not waiting on your heels for something to happen. So that's Sandison versus the Michigan High School Athletic Association. Very interesting case. It's interesting that the court actually only looked at one piece of that, which was the discrimination. I think in my own conclusion, it seems to be like they wanted to make a point out of this case for future cases, if you're only looking at one side of the case and ruling, like they said, based on one side. So that's something to keep in mind. Again, that's Sandison versus Michigan High School Athletic Association.